Imagine you're driving home from a late shift, the highway is empty, your music is low. Then the flash of red and blue appears in your rearview mirror, and your heart jumps before your brain has time to think. You pull over, you roll down the window. The officer walks up, leans down, and asks the very first question that catches most drivers off guard. Whatever you say in the next 10 seconds can decide whether you walk away with a warning, leave with a ticket, or get pulled into something far more serious. Most drivers have never been taught what to say, and more importantly, what not to say in that window of time. By the end of this video, you'll know exactly why certain common phrases hurt you, what your constitutional rights actually allow you to do at a traffic stop, how the rules vary depending on where you live, and how to handle the situation calmly without giving up anything you don't have to. There is a popular idea floating around the internet that there are 5 magic words you should never say to a police officer. You've probably seen the thumbnail. The framing is usually dramatic, the title is clickable, and the implication is that there is some official list, hidden by lawyers, of forbidden phrases. There isn't. What actually exists is a set of well-understood legal principles, drawn from decades of court decisions and constitutional rights that explain why certain common responses can seriously hurt you. The 5 words framing is a teaching tool. The real lesson is bigger. So instead of memorizing a list, let's walk through the principles behind it. Because once you understand the principles, you'll never be rattled by a traffic stop again, no matter what the officer asks. The first principle is the simplest, and it's the one most drivers violate without realizing it. When an officer asks, "Do you know why I pulled you over?" Although the question feels harmless, almost conversational, you assume they want you to admit something so they can move on. The honest, polite answer feels right. The problem is that this question is a routine investigative tool. It's designed to elicit an admission. If you say, "I was probably speeding," or "I might have missed that sign," you've just made a statement against your own interest that the officer will write down and, if it ever matters, present in court. The principle here is that you're never required to answer questions about what you did. The polite, constitutionally sound response is something like, "No, I don't," or simply, "I'm choosing not to answer questions." Aye. You can be polite and firm at the same time. You're not being difficult. You're protecting yourself. Nothing in the law requires you to help an officer build a case against you. That brings us to a quiet detail that surprises almost everyone who hears it. Miranda rights, the famous warning about silence and attorneys, do not usually apply during a traffic stop. The U.S. Supreme Court addressed this directly in the case Berkemer v. McCarty, decided in 1984. The court held that a routine traffic stop is generally not the kind of custodial interrogation that triggers the Miranda requirement. In plain English, this means an officer can ask you questions during a traffic stop without first reading you your rights. Anything you say can be used later. The protection you're relying on in that moment isn't Miranda. It's the Fifth Amendment itself. The Fifth Amendment gives every person the right to remain silent and to avoid answering questions that may tend to incriminate them. You don't need a warning to invoke it. You simply do invoke it. The text of the amendment doesn't depend on a script being read to you first. So in a traffic stop, you assume Miranda is not coming and you rely on the underlying constitutional right instead. So how do you actually exercise that right? You state it clearly and calmly. The most common phrasing taught by civil rights organizations is something close to, "I'm exercising my right to remain silent," or "I do not want to answer any questions." You don't need to be rude. You don't need to be aggressive. You simply state it once, clearly, and then stop talking about the substance of the stop. From that point on, you only respond to requests that the law actually requires you to respond to, which we will come to in a moment. Many officers are trained to keep asking questions even after you invoke silence, in the same casual tone. They may say, "You don't mind if I ask, do you?" Or, "Just help me out here." The polite answer remains the same. You've already invoked. Keep invoking. Each new answer resets the conversation in a way that can hurt you, which leads naturally to another subtle phrase that can damage you, the words, "I'm sorry." Most of us treat an apology as a basic human courtesy. At a traffic stop, that simple apology can be interpreted as an admission. If the officer says you crossed the line and you say, "I'm sorry, I didn't realize," you haven't apologized for the weather. You've apologized for the conduct you were accused of. Especially if a camera is recording. That apology is now part of the record. Now, you can still be kind. You can say, "I understand," or "Thank you, officer." You just want to avoid words that can be reframed by a prosecutor as a concession. The tone you set matters, but the words you choose within that tone matter even more. The first widely cited forbidden phrase in the internet's unofficial list is along these lines. It captures the idea of admitting guilt. Sometimes it is interpreted as the word "yes" when an officer asks whether you were speeding. Sometimes it is interpreted as words like, "I think I was." Sometimes it shows up in content as the word "maybe." The unifying principle is the same. Any admission, however qualified, can be used. Defense attorneys will tell you that, "I guess so," "I'm not sure, but I might have been," and kind of, yeah, are all forms of admission. The defense team has to spend effort getting those words explained away. If you avoid the admission entirely, that effort doesn't need to be spent at all. You just say you don't want to discuss the reason for the stop and move forward. Now let's talk about the phrase that may be the most consequential of the entire interaction. It doesn't come up at the start. It usually comes up near the end, after the officer has taken your documents and is walking back toward your car. "Do you mind if I take a look inside?" Or, "Is it okay if I search the vehicle?" The temptation to say yes is enormous. The officer seems reasonable. The officer may even say, "It'll only take a minute." But here's the legal reality. The Fourth Amendment protects you against unreasonable searches and seizures. A search of your car is reasonable only if the officer has probable cause, a warrant, an exception to the warrant requirement, or your voluntary consent. If none of those first three apply, your consent is the only thing that lets the search happen. Without your consent, the officer would have to go find a judge, get a warrant, and come back. The Fourth Amendment, as applied to vehicles, goes back to cases like Carroll v. United States in 1925, and the basic rule has been refined through decades of follow-on decisions. The simple takeaway is that you're almost never required to consent. Saying no doesn't mean the officers can't still do the search. If the officer truly believes there's probable cause, they can search anyway. But if there's no probable cause, your no is the legal wall that protects you. The exact wording you can use is also simple. "I do not consent to any search of my vehicle." You can repeat it. You can withdraw consent if you gave it earlier by saying, "I'm withdrawing my consent for this search." A consent previously given, even casually, can be a problem later. Withdrawing it doesn't erase what was given, but it does limit what happens next. Why does this matter so much? Because many traffic stops that start over a minor violation end up producing serious criminal charges after consented search. An officer may ask to search for several reasons. The most common is that the officer hopes you'll agree. Even experienced officers acknowledge that consent-based searches routinely uncover evidence that would have been unreachable otherwise. From a purely legal standpoint, that's a feature of the system working. From the standpoint of an everyday driver who just wants to get home, it can mean an arrest that would never have happened. Saying no doesn't make you suspicious. It exercises your rights. Defense lawyers consistently recommend that ordinary citizens decline consent in almost every situation, because the reasons to consent are rare and the risks are real. Now, a question that comes up constantly. Do you have to give the officer your name, your license, registration, and proof of insurance? The answer is yes, with practical nuance. Every state requires a driver operating a motor vehicle on a public road to produce these documents on request. The Supreme Court's decision in Delaware v. Prouse from 1979 made clear that the stop itself has to be supported by reasonable suspicion or probable cause of a traffic or equipment violation, but once a valid stop occurs, producing these documents is part of what the law requires. Refusing to hand them over can lead to additional charges that have nothing to do with the original reason for the stop. Politely comply with that request. That isn't the same thing as answering questions, and it isn't the same thing as consenting to a search. What about your name outside the driver's seat when you're a passenger? The answer varies dramatically depending on where you are. Some states have what's called a stop and identify law. The ACLU and other civil rights organizations track this carefully. States that impose a clear legal duty to identify yourself during a lawful investigative detention historically include Arizona, Indiana, Louisiana, Nevada, and a few others, though exact lists have shifted over time. In the majority of states, you are not legally required to provide a passenger's name during a routine traffic stop unless the officer has reasonable suspicion that you've been involved in a crime. Even in states with a stop and identify law, the duty is generally tied to being lawfully detained, not merely to being in a stopped car. As a practical matter, the driver and passenger situations are different. The driver almost always has to identify. The passenger often does not. If you're a passenger, the constitutional principle, drawn from cases like Brendlin v. California, is that passengers are also seized during a traffic stop, which means they have protection against unreasonable detention, but the duty to identify is much narrower. The safest approach in any passenger situation is to ask if you are free to leave, and if the answer is no, to politely ask for the reason. That question, am I free to go? Or its variant, am I being detained? Is itself one of the most useful phrases a person can say during a traffic stop. It is not on anybody's forbidden list. It clarifies the legal posture of the entire interaction. If the officer says yes, you're free to go and the stop is over. If the officer says no, you've established that this is a detention, which carries constitutional protections. You can ask the question and then remain silent. That two-step process shifts the conversation from one where you're being questioned to one where the legal status of the encounter is documented on the officer's recording. It is the kind of phrase the ACLU recommends, and civil liberties lawyers teach it in Know Your Rights trainings across the country. Now let's address a related idea. Some content circulating online suggests that the phrase, "I know my rights," is itself a forbidden phrase. The legal reality is the opposite. The Supreme Court has made clear across many decisions that you have a constitutional right to tell an officer you intend to invoke your rights, and the act of saying so is not an offense. What the phrase might do in practice, however, is change the tone of the encounter. Some officers interpret it as the start of a fight. The most experienced civil rights trainers recommend a softer form in the moment. Not, "I know my rights" alone, but "I'm exercising my right to remain silent," or "I would like to speak with a lawyer before answering questions." These statements accomplish the same legal goal while keeping the encounter calm. The substance should be firm. The phrasing can be soft. Both are protected. Another common piece of advice concerns the word "nothing." It's tempting to respond to questions by saying, "I don't have anything to say." The principle is solid, but the phrasing matters. In some encounter dynamics, "nothing" has been reframed by officers as a refusal that suggests a more serious concern. The safer approach is to stay specific. "I'm exercising my Fifth Amendment right to remain silent." That statement has an unambiguous legal meaning. It cannot be twisted. Saying nothing can be, especially if it later becomes a question about whether you actually invoked your right to silence for Miranda-type purposes. The point here isn't paranoia. The point is precision. Phrases that are precise protect you. Phrases that are casual can be argued over later. Let's also clear up the anxiety around recording. The First Amendment generally protects the right of citizens to record police officers performing their duties in public. Courts across the country, including decisions in the 1st, 7th, and 11th Circuits, have repeatedly recognized that right. The Supreme Court has not ruled on it directly, but the consistent lower court direction is that recording is a form of speech and reporting on government activity that the Constitution protects. That said, you can't interfere with an officer's duties, and you can't obstruct. From inside a stopped car, recording has become especially common because almost everyone carries a phone. The practical rule is to record visibly. Keep your hands visible and avoid reaching for the phone in a way that might be perceived as reaching for a weapon. You can usually press record and lay the phone on the dashboard. In some states, audio recording consent rules apply, but in most public encounters, recording the officer is protected, even required, for documentation purposes. A subtle but important question is, what happens if the officer asks to search your phone? The same Fourth Amendment principles apply. You do not have to consent if the officer believes they have probable cause, and in some cases, if exigent circumstances exist, they can search without consent. But consent is still one of the easiest ways for an officer to get at information they couldn't otherwise reach. Phones contain an enormous amount of personal data, including location history, contacts, messages, photographs, and any app data. The legal standards for searching a phone are higher than for searching a car, anchored in cases like Riley v. California, decided in 2014. The Supreme Court in Riley made clear that warrantless searches of cell phones in most arrest situations violate the Fourth Amendment. That protection extends to many traffic stop situations, particularly if the officer is relying solely on consent. So, if asked, the same simple answer works. I do not consent to a search of my phone. Let's talk about the broader practical structure of a traffic stop, because the principles we've discussed only matter if you can apply them under pressure. The most common pattern, and the one that helps drivers stay calm, has a handful of steps. You see flashing lights. You signal, pull over to a safe spot, and stop. You turn off the engine, roll down your window, and put your hands where the officer can see them. When the officer approaches, you can ask, "What is the reason for the stop?" That's a question you're allowed to ask. The officer's response tells you what document you'll need. You can produce your license, registration, and proof of insurance without volunteering anything else. If the officer begins asking investigative questions, you politely invoke silence. If the officer asks to search the vehicle, you decline. If the officer tells you that you're free to go, you go. That entire interaction can take a few minutes, and most of your rights are exercised by what you don't say, rather than what you do say. The moments that go wrong are almost always the moments where a driver treats the stop like a normal conversation. They try to explain, they apologize, they guess why they were pulled over, they make small talk. They agree to the search because the officer sounds friendly. None of these responses are illegal. None of them will automatically lead to an arrest, but each of them carries a small legal risk that compounds. Courts and prosecutors look at the totality of what was said. A polite, defensive evidentiary quiet record is much easier to defend than a conversational record that includes an apology, an admission, and a consent. You don't have to be a difficult person to make the right choices. In fact, the easier, calmer driver is often the one who walks away with a warning. Now, an honest note on variation. Federal constitutional rights apply everywhere in the United States. The Fourth Amendment stops an unreasonable search, whether you're in Maine, California, Texas, or Washington. The Fifth Amendment protects against self-incrimination in the same way. But the details of when identification is required, when an officer may escalate a stop into a longer detention, what counts as reasonable suspicion, and what specific traffic statutes apply are determined by state law. The principle that you don't have to consent to a search is constant. The exact procedure for how you communicate that refusal and what additional state-specific consequences may follow varies. The content in this video is general educational information, not legal advice. If you want to know the exact rules in your state, you can look at your State Bar Association's consumer pamphlets, your State Attorney General's office, or your local ACLU affiliate. Those sources update their materials as the law changes. One last note on officer training and tone. Officers vary. The same law is enforced by people with very different styles. The vast majority of officers are professional and recognize that a calm, rights-aware driver is just doing what the Constitution allows. Some officers use conversational pressure to elicit admissions. A few officers, unfortunately, will frame a driver's invocation of rights as hostility. The law protects you regardless of how the officer reacts to your words. Being polite, being visible, keeping your hands in sight, and exercising your rights crisply is the right combination. If you ever feel a stop is escalating beyond a routine encounter, your strongest move is to repeat calmly, "I want to speak with a lawyer." And that phrase is one of the most powerful in American constitutional law. Once you ask for a lawyer, the entire question and answer dynamic is supposed to stop until counsel is present. It is not always respected in practice. It is always respected in principle, and the legal record it creates matters later. If you remember nothing else from this video, remember this. A traffic stop is a moment where constitutional protections matter more than social niceties. You can be kind, you can be respectful, you can hand over your documents, you can answer the basic questions the law requires. You do not have to guess at why you were stopped. You do not have to admit anything. You do not have to consent to a search. You do not have to keep talking after you've invoked silence. The so-called forbidden phrases aren't a secret list. They are the natural output of small mistakes that compound. Avoid the admissions, avoid the consents, avoid the apologies. Invoke silence clearly. Ask if you're free to go. Decline the search. Decline the phone search. Wait for the lawyer if things move past the routine stage. That single mindset, applied in real time, is the most important thing this video can give you, because the next time those lights flash in your mirror, you won't be guessing. You'll already know what to do.